All right, we got a good amount of us here. Let's get started. Again, my name is Barine Majewska. I'm counsel here at Vicente, and I co-lead our psychedelic practice group with Josh Kappel, who, if you don't know, I'll be introducing in a minute here. We're excited to have all of you here today. It is a fun and novel time in Colorado. As we mentioned in our blog, we don't really stand still here, so we are continuing to move forward. We're going to first talk about the Ibogaine pilot program, since judging by my phone calls and emails, that's what everyone is most excited about. Then we're going to talk about Ibogaine more generally, not just the pilot program. And then we're going to move on to talking about the somewhat less stimulating, but still very important changes to the existing natural medicine laws. And those will be very significant for those of you already operating in the space or wanting to operate in the existing natural medicine program. We should have a Q&A channel open in the chat. I think that's private, so we can see that for you guys. But please post your questions in there rather than in the general chat, and then we'll do our best to address many of them at the end, depending on how much time we have. Um, this webinar probably could be 2 hours. We're going to try to keep it a lot less than that, obviously, and stick to our scheduled 1 hour. But yeah, put your questions in there. We'll do our best. And our usual disclaimer, please remember that this webinar is for informational purposes to introduce you to the topic, and none of what we're saying here constitutes legal advice. There's a lot of nuance here, as those of you already operating in this space know, and a lot of this is very fact dependent. So if you want to enter Colorado's natural medicine program, or you have questions about how you're currently operating, please set up a call with us to discuss your specific situation and details, and we can go from there. All right, let's get into some intros. We have Dave Kopilak here. He's a new partner at Vicente in our psychedelic group. He joined us from Merge Law. Some of you may have already worked with him in Oregon or are starting to work with him through Vicente. We're very happy to have him here. Josh Kappel, who many of you probably already know, he's one of our founding partners at Vicente. He's been instrumental in getting this entire Colorado program going, from Prop 122 to the Senate bill to all the implementing regulations, and now this new bill that we're talking about today. He was really involved in the drafting and supporting of this Ibogaine piece. So we're excited to talk about that. And related to that, shout out to Colorado for Ibogaine, one of our clients that we worked with intimately on moving this Ibogaine piece forward. All right, so with that, I will jump right in. HB 261325, it doesn't really roll off the tongue, passed with overwhelming bipartisan support, and Polis has indicated that he will sign it. Once signed, rulemaking will take place on the specifics of how all of this will work. We'll get into some more of those details. And if it does move into our regulatory framework, the Department of Revenue that oversees the regulatory licenses now will put in Ibogaine into that framework, and we'll know how that works. The overall law is expected to take effect on August 12th, 2026, pending governor's signature. And with that, let's get into the nitty gritty. So Josh, let's go to you first to talk about this Ibogaine pilot program. It's first of its kind, and there's a lot of details that I think our listeners should know.
Thanks, Verena. Um, pleasure to be on this webinar with you, and Dave. It's exciting and awesome to have you as part of the team. And you've represented so many of these businesses in Oregon, so it's just really nice for that cohesion. We've learned so much from that from the collaboration with the merge. Um, okay, so breaking news: the bill is signed as of maybe an hour ago. And so it's now the law of the land. It still goes in effect on August 12th. There's a great sort of signing ceremony where this Republican sponsor of the bill, the House Minority Leader, spoke about how he is a conservative Christian and never thought he would support psychedelics, but he did, and he supported this Ibogaine bill, based off of how he saw it help people, who also served in the armed forces with him, and likewise the Senate sponsor, Senator Ball, is a progressive Republican or progressive Democrat. So it's a great bipartisan bill, that moved forward. And so, what is this Ibogaine pilot program? It's at the end of the day, it's there's a couple caveats and a couple things to know. So just laying the groundwork. The the two pieces of this bill as it relates to Ibogaine, arguably three pieces of the bill as it relates to Ibogaine. One is it sets up a pilot program under the Behavioral Health Administration. So that's like, bucket one, pilot program. Bucket two is that it changes the Natural Medicine Advisory Board to like add more Ibogaine experts. And then bucket three is that it lays the groundwork under the Natural Medicine Health Act for the inclusion of Ibogaine in the future. And so for those um, okay, hopefully you can hear me better now. And so, for those who, remember like the Natural Medicine Health Act, starts with psilocybin. Like on the regulated side, it's just psilocybin and psilocin, but there's the ability for other natural medicines to be added to it. And sort of the first one that the state has been looking at is adding ibogaine to the Natural Medicine Health Act. So that is the three buckets. So you have pilot program, changes to the National Medicine Advisory Board, and then a future regulatory program. Now another big caveat here is the state of Colorado is in like a budget crisis this year. They, in the summer they had to call a special executive session where they're $800 million short. A lot of this was due to the federal House Bill 1 that took away a lot of federal funding from state programs. And so the state of Colorado has been in this crisis around the budget. And there's a couple other structural factors in Colorado that make it hard or impossible for the state of Colorado to just save any money. But putting all that aside, the issue, the big piece around ibogaine in Colorado is that both the pilot program and the full regulatory program are contingent on adequate funding. And this bill did not allocate the funding necessary to move those two programs forward. It did create a pathway for, for the agencies to obtain grants, settlement dollars, federal research dollars, or private philanthropy to be able to move these programs forward. And so, a lot of folks were like, hey, we, want to, start this pilot program now. It's also contingent on, the necessary funding. So in order for the pilot program to move forward, the state of Colorado needs around $150,000 on the full regulatory program to add ibogaine into the natural medicine program. That the state needs like closer to $1 million. And those are all, yeah, there's a lot more conversations. If people are interested in or have sources of funding, please contact us.
Josh, would you just speak to the deadline for the pilot program because it's come up with a lot of folks. So when do we have to have that 150K raised by for the pilot program to fire?
Yeah, it's January 1st, 2028, if I'm correct. So it is, it's not going to sit out there forever. So we need to like make some moves. Now on the regulatory side, the regulatory program, there's no deadline for that to happen. That's sort of built into the law. Maybe 3 or 4 or 5 years from now, the budget situation in Colorado will be different. Maybe there's ways to like regulate it, at in a different way. There's like, more options there, but it's, a longer process. And okay, so what is this pilot program? Okay, so what it is that in the Behavioral Health Administration, assuming funding, the BHA will create rules around the program first, and they'll select up to 5 pilot sites that they will support in both navigating federal approval and also like obtaining grant funding and other funding sources to actually run ibogaine trials. Now, the federal approval that's like that's part of this pilot program could be an investigative new drug application, a phase 1 study. It might also include operating under the right to try, or potentially like seeking some sort of waiver under other provisions of U.S. law. But the big piece is that in order for the pilot sites to operate, they do need federal approval or federal legality in some manner. And so most likely what this will look like is these pilot sites will be part of either their own IND or part of an existing IND. And what and what the law allows is it allows for the pilot sites to be part of like other multi-state consortiums So there's, as many of you know, around Ibogaine, Texas, put in 50 million, potentially 100 million into the drug development around Ibogaine. Other states have thrown in money. So one of these pilot sites could be part of that whole consortium, but it doesn't have to be. And it also could be that these pilot sites, if could be part of the Right to Try Act. For those who don't know what the Right to Try Act is, it's a federal law that allows for certain substances or medications that are going through the FDA process that have passed phase 1, that it allows them to be used for those with terminal illnesses. Recently, the Ninth Circuit, said that this doesn't apply to Schedule 1 controlled substances. However, there's a recent executive order that sort of directs the DEA to issue, some sort of Schedule 1 authorization for the Right to Try Act. Whether or not the DEA will do that, so remains to be seen. And so a couple other pieces around the pilot program, one is the only other mandate in the law is that there needs to be some form of a benefit sharing plan with Indigenous communities. So if you're a pilot site, you have to have some form of a benefit sharing plan. And then another benefit for these pilot sites is if and when Ibogaine is added to the Natural Medicine Health Act, the pilot sites get first priority. And actually, there's another benefit too, is if you're providing Ibogaine under the pilot site, there are some limitations of liability. Ibogaine is a very new substance, and so there's some limitations of liability that also have some carve outs. And so that's the pilot program in a nutshell. First step, we have to fund it. Second step, there'll be a rulemaking process with BHA. Third step, people will apply, be selected, and then BHA will work with them to obtain federal approval and additional funding. And Barine, that is what I got for you on the pilot programs.
Thank you, Josh. Super helpful. You've said this, but just to reiterate for the audience, especially if folks are getting bounced out from time to time, and because it's a question I've gotten a lot, the pilot program is different than it's a different creation. It's a different creature than the psilocybin is in our regulated program, or all these natural medicines are under personal use, right? So right now we have this dual prong system. We have a regulated system that covers only psilocybin, and we have personal use that covers psilocybin, DMT, mescaline, excluding peyote, and Ibogaine is included in personal use, but you can't share it. So just hold that thought for a moment. So we have this dual prong system right now in Colorado, right? So this is not actually what Josh just talked about, is not adding Ibogaine to that existing regulatory structure. We're about to talk about that next. That is a separate creation. That's a pilot program for which you'd have to get, in addition to the Colorado requirements, you'd have to get federal approval to work in that pilot program structure. So it's an entire infrastructure that Colorado has built, but it only fires once it has the 150K funding requirement by January 1st, 2028. And it only fires for an individual pilot site that has federal approval. Okay. So just trying to keep these conceptually distinct because we're covering a lot on this. So that's what we've talked about up until now. And that's what we're calling the Ibogaine pilot program. The next piece is from the beginning, there has been a directive for the advisory board to consider adding Ibogaine into the regulated program. So alongside psilocybin with different rules and regulations, but so that it could be administered in healing centers through licensed facilitators, just another addition to the state regulated program. So Josh, let's you and me chat about that a little bit and distinguish that from the pilot program you just discussed. So that also has a funding requirement, right? Before that fires, but it's not the 150K.
Correct. So it's in order to add Ibogaine into the Natural Medicine Health Act, which maybe it's at healing centers, maybe it's at a special type of healing centers, maybe it's at healthcare facilities. There's a lot of unanswered questions. The state needs the adequate funding to properly regulate this, and part of it is because Ibogaine there have been deaths associated to it. A lot of times related to inadequate detox or post use reintoxication and or cardiovascular diseases. And so in order for the state to really create safe rules around this, we need to think about it thoroughly. And that sort of that process on one hand is like starting with the Natural Medicine Advisory Board now, but to really like dive in and to set it up, like more funding is needed for the state.
Yep. So we don't have a definitive start date for the implementation of Ibogaine into our existing regulated program. And it they're not actually required to add it until DOR has the appropriate resources to staff, administer, and program this thing. So that's important to note. A few other interesting things to note there is, as Josh mentioned, and I think this is fairly non-controversial, Ibogaine is dangerous in a way that none of these other natural medicines we've talked about are. It's pretty well understood that there are risks involved with that psilocybin, DMT, and mescaline don't have. So, given that we're setting this program has set up pretty careful monitoring, the regulators will have the authority to require a much heavier screening, like a medical pre-screening that includes electrocardiograms, blood tests, continuous medical monitoring during an administration session, oversight by trained medical professionals, aftercare and integration that's beyond what is required right now for psilocybin. So there's an entire other screening and monitoring and aftercare that's associated with Ibogaine administration sessions that we can expect to see rulemaking around. Um, what else do we want to say about that? If it is included in the regulated program, the definition of natural medicine will be expanded to include semi-synthetic ibogaine derived from two different plants, and that's in contrast to the current natural medicine rules, which don't allow any synthetic or semi-synthetic forms of the natural medicines currently approved. What else do we want to say?
Yeah, I mean, and so this is like a really interesting question that we've had this whole time, which is like, well, where does Ibogaine come from under the Natural Medicine Health Act? And under the pilot program, remember, pilot program separate, but like you have federal approval, and with federal legality, there should be the ability to import Ibogaine in some form. Now, the state program, you know, is not is really not federally legal. Granted, there are ways that like these pilot sites could be federally legal, and hopefully we can figure that out. But absent federal legality, there's not really a way to import iboga into Colorado. Because otherwise, like the answer would be clear. Let's like import iboga through ethical and fair and sustainable practices. Let's be part of the Nagoya Protocol. But this federal legality issue creates a problem. And so, what people have been, so why it was expanded in Colorado around, adding other types of plants where you could create ibogaine was because, like, honestly, we don't know where the sourcing is going to come from, under the Natural Medicine Health Act. And so for those who are listening who are, cultivators of iboga or consider themselves really good cultivators, like you can grow iboga legally now in Colorado. It's decriminalized. Like, like see if it, you can see if it's possible. And a lot of people don't believe that it's possible. But I would love to be proven wrong there. And another big piece though around the Natural Medicine Health Act inclusion of ibogaine is the requirement for a benefit sharing plan. And so again, it's like it's not like clearly like, hey, this needs to be part of Nagoya because there's like issues with like Colorado being a signatory. But the benefit sharing plan that's mandated under the Natural Medicine Health Act for any business, a cultivator, a healing center, anyone who's working with iboga, has to be based off of consultation with indigenous communities that work with iboga. And that could be, that group individually, or you could work with, an intermediary group like Blessings of the Forest or someone else, and so there's, this mandate to engage in consultation and then create a benefit sharing plan based off of that consultation. And the benefit sharing plan can be financial, but it doesn't have to be. And if you look in the law, there's actually like a couple different like things that talks about like what the benefit sharing plan could be. It could be like collaborating on research or data sharing, conservation support for species and habitat, community identified development priorities, cultural educational exchanges, utilizing a source of ibogaine that is, engages in benefits sharing itself. So there's like a bunch of different there's a lot of flexibility there, but it is something too of like for those who are looking to engage in this under the Natural Medicine Health Act, if and when that becomes available, that's like a process you can start doing now. Engaging in consultation, creating a benefit sharing plan is a long process and a resource intensive process.
Thanks, Josh. Just want to underline a couple things you said. Like you said them. I just want to emphasize them because we're giving these guys a lot of information. Ibogaine is legal to cultivate within the restrictions of personal use right now for your own personal use. Ibogaine is not legal to share under personal use and not to sell. Like the other natural medicines are also not legal to sell. Everyone listening probably knows that, but worth emphasizing, Ibogaine is its own in its own category in that you can possess it, you can cultivate it, but you cannot share it under personal use. So that's where it's saying, again, wanting to emphasize Josh's point about the benefit sharing. The benefit sharing plan is a requirement as part, if you don't have it as part of your pilot site application, once the pilot program is launched, you won't get approved. So you have to have a benefit sharing plan as a condition of getting approved as a pilot site. And then it is an ongoing requirement once Ibogaine is included in the regulated natural medicine program as well. You have to have a benefit sharing plan and it has to be available for public review. And you have to maintain it in an ongoing fashion. So that's built into both the pilot program and inclusion of the Ibogaine in the regulated program. And I had another point that I don't, oh, the federal approval. So federal approval is required for participation in the pilot program. That's important to know. It is not required for participation in the regulated program once Ibogaine is included. Then Ibogaine would act largely like psilocybin in that sense. We would have a state legal program that contradicts and runs parallel to federal law. So just points worth emphasizing. These are questions that have been coming up a lot. All right, Josh, anything else we want to say about Ibogaine in general?
I mean, I think that is, yeah, I mean, that's all I got for us today on the topic. Feel free to reach out. I think it's, a big shout out to everyone who helped us move this bill forward, around that piece. And, it's the idea is to collaborate with this national movement, international movement around, creating access to Ibogaine care for opiate use disorder and otherwise very difficult to treat mental health illnesses. And also then the caveat that, it's not for everyone, is not there are risks associated with it, and so that's where we're at.
Awesome. Yeah, we've got a lot of national firsts here, like personal use. We have, the benefit sharing mandates are a nationwide first. The Ibogaine pilot program is a nationwide first. So we're in very cool new territory here with regards to Ibogaine. Okay, so that's what we've got on Ibogaine. We'll circle back at the end for questions. I'm sure you guys have some. We're going to now go to the slightly less shiny but still very important topic of changes to the existing natural medicine law. There have been some pretty significant changes that you guys should be aware of if you're operating in this space. I think we will go first to this natural medicine sales license, and I'll go to Dave for that. Yeah, please talk to us about this new license category that was introduced, some context about what it is, why we think it was introduced, what consequences does it have for folks and their corporate structuring and their tax planning. And let's start there. Dave, you might be muted if you're talking.
Sorry, there we go. Hi,
Thanks.
everybody. Glad to be here. I joined Vicente back in December. It's been great. I had a firm in Oregon, and we launched our psilocybin program a year or two before you all did, and we had a head start on that. And I'm a business and corporate lawyer, so we were, putting our heads together back in Oregon about how to structure. We call them service centers. How to structure these businesses. I always thought they were the riskiest license to have. I always, whenever I had a service center client, I'd say something like, I admire your bravery, trying not to dissuade them from entering the space in the first place. But I always thought these were the folks who were signing leases and setting up, building out a premises and really taking on some risk. So, of course, my job as a corporate lawyer would always be to, how are we going to structure your business? And for any business in any industry, you're thinking about oftentimes you're thinking about taxes and limiting your liability, right? Like those are two of the main issues you talk about when you're forming any entity for anybody. So and I'll speak in Oregon terminology for a second. I'm going to harken back to our early days for a few minutes in Oregon. So, from a liability perspective, we had zero insurance, right, from the get go. There was always products liability insurance and general liability insurance, but for the facilitators and the service centers, there was no professional liability insurance. There was no malpractice insurance. All lawyers, doctors, accountants, everybody else has malpractice insurance. Facilitators, who were often therapists or had other licenses, those other licenses had insurance, but no such thing for facilitators. Um, so, that's a big liability risk right there. And then you had this tax issue with 280E. I'm assuming everybody knows something about 280E. It's an Internal Revenue Code provision that says if you're trafficking in a controlled substance, then you can only take certain deductions. This is a simplified version of it. And those deductions are cost of goods sold. Now, all cannabis businesses are subject to 280E and they deal with it. But a lot of the cost of goods sold is kind of an inventory concept. And the interesting thing with psilocybin, of course, was the products, the inventory is very minimal. The bulk of the money is going towards the services where you've got zero cost of goods sold. So how are we going to deal with this? How are we going to structure this? After noodling on this for some time and talking to CPAs and thinking about it, we came up with what we thought was kind of the best practice structure in Oregon, which was as follows. We would, and I should say, half of our clients do this and half of them don't because oftentimes lawyers recommend things to people or say, hey, this might be the best practice, the best way to do it. You could do it this way or this way. There's no right or wrong answer. And some folks are by nature more conservative and more inclined to play defense, and other folks want to keep things simple. And so, it's a lot of it depends on what the client's appetite is for risk or anything. So, but we said, hey, if you're playing defense and you want to protect yourselves the most, we think you could do something like this. Form two entities. Every time I tell someone to form two entities, their eyes roll a little bit and say, oh, isn't that going to be more complicated? But we form two entities. They hold the service center license together as co-licensees. One of the entities buys and sells the psilocybin products. We don't call it medicine back in Oregon, the products. And that's the trafficking entity for tax purposes. Now, the dollars that are going through that entity are extremely minimal. You're buying and selling a product for a nominal amount. You're paying a small portion of the rent. It's not a big deal. So you're trafficking, keep it isolated. Everything else, services, room rentals, anything like that is for your entity number two. You take the position that's not trafficking. Okay, so that sort of isolates the trafficking entity from the non-trafficking entity. From a liability purpose, oh, and by the way, the trafficking entity isn't providing any services at all, right? Like they're not providing services, they're just selling products. Entity number two is either or providing services or renting rooms to facilitators who provide services. And we thought for maximum protection, the service centers would not even provide services. Ironically, it's a service center, but we're not providing services. How would we do that? Well, we would rent space to facilitators who had their own independently established businesses. And the idea was I'm coming from a service center standpoint. The idea would be, hey, if something goes wrong, nobody has insurance. If somebody's going to sue somebody, the service center would point the finger at the facilitators and say, hey, we didn't provide the services. All we did is rent the room out. This facilitator over here provided your services. That's who you should be going after. So if the facilitators out there could say, well, great, you're throwing me under the bus here, um, and pointing the finger at me. But from a service center's perspective, we thought that was the way to go, and that's what a lot of folks do in Oregon. They rent rooms out to facilitators who have their own businesses and provide the services to the clients. So we had one or two folks in Oregon who were up and going in Oregon, who once Colorado comes online says, "Hey, let's I want to expand into Colorado." Great. Um, my business model is working well here. Let's do the same thing in Colorado, right? Yeah, sounds good to me. Um, Problems developed, issues developed. Um, DOR said off the bat that they kind of flip flopped on us for this, but they said you can't have two entities holding the license. You can't do it. Why not? Because you can't. Our hands are tied. It's in the rules. Okay. So that sort of made it a little more challenging and difficult. And then they later on, once we got set up and passed that one, um, we I don't think any of us knew this from the outset. The DOR took a position. This was a bulletin they put out, but I think that came as a result of some issues that we had with one or two of our clients who were basically having, selling the product to the medicine to the participant, perhaps maybe on the day of the session, of the administration session, and charging them some nominal fee for the product. And DOR says, well, you can't do that. You can't sell the product. Uh, my initial thought was, well, why not? Of course, why not? Point me to something that says I can't do that. And we haggled over them. We had different interpretations of this, but at the end of the day, it said you can't sell the medicine to anybody. Well, how do you do that then? Well, you have to bundle it together with the services. And now, what I had just mentioned in Oregon, what we were trying to isolate the product from the services and isolate things from other things for tax purposes and liability purposes. And now you're saying we have to bundle them together. So we had issues where we were struggling with how to sort of somebody who might be interested in having this sort of defensive business structure. It was much easier in Oregon. We were having challenges here in Colorado. I think as a result of all this, one of the things this legislation did was to create this, it's a pretty long name for a license, limited regulated natural medicine sales license. So it's a new license. And I think the point of this is that it was, I suppose, the legislature's fix and perhaps DOR's fix to say, like, okay, you guys can form some other entity if you want to get this other sales license, so you can bifurcate have this entity with this sales license. I'll just call it a sales license. Sell the products while your other entity does everything else. So you all are now sitting there probably thinking, well, do I need to do this other license? The statute itself says you don't have to do it, right? This is sort of an opt-in extra license that you can get if you want to pursue a certain business model. So, should you get this license? Yes or no? The answer is there's no answer we could give you right this minute. Some folks might want to get it. Some folks might not want to get it. It depends on how you're structuring your business. And I always think of ways I try to say, like, look, here's the law. We're stuck with this and we're stuck with this. We want to have best tax benefits for you. We want to limit your liability, or at least give you options how you could take the most conservative approach to limit your liability. And here's different ways we could do this. And I think we have to, even ourselves, I think we have to talk through what's still possible and what's not possible. So for the moment, I'm going to say, if anyone's interested in exploring whether they should get this sales license and how it fits into their current business model, I would say we need to discuss it, with us and perhaps a CPA. And now might be a good time to step back and think, hey, is the business model that I launched this healing center with, does it still make sense? I mean, this happens all the time where it happened in the cannabis business forever. We'd set up these structures or we do this or that. A couple years down the road, we'd be like, okay, this is, this is too complicated. Let's simplify it. Or, oh, we should have done this, or we should have classified things this way. And you can oftentimes restructure things. So it might make sense for everyone to kind of think about it. Insurance is still out there as a big issue. We have no insurance in Oregon. There are policies floating around that folks have signed up with that I've reviewed, and I think they're barely worth the paper they're written on. There's exclusions for mental health, and if you read the exclusions, which of course these policies are all set up for, it's really tough. And so some folks think they're insured more than they are.
Thanks, Dave. And I think, it's like, hopefully, this, two entity approach that's permitted by the sales license, maybe that'll solve some of the insurance issues, or you'll have like a reasonable insurance policy for like general liability, even though you might not have malpractice coverage that's like meaningful. I think, the other factor too that's like really important at when people figure out whether or not to pursue the sales license is there'll be rules that come out about what this looks like, including the cost of it. So for like a small business, it's like, oh yeah, it'd be nice to have that structure from like a tax strategy standpoint, but is it worth $2,000 or $3,000? Or maybe it's like, hey, it is worth $1,000. So, like a lot of it's going to come down to like the cost, especially on the smaller businesses, to determine like whether this is worth it or not. So there's still some to be determined things. And Dave, I appreciate, your deep understanding of like the layout of it all.
Yeah, and again, some folks just want to go simple. Some folks want to sort of, but it's worth thinking about, at least talking it through for a little bit, so folks know their options. The other thing I'll say is unrelated to this license in the act. There is a provision that limits liability to some extent for facilitators, which I thought was really great. It I think it's not it doesn't mention healing centers, so it just applies to facilitators. And I think there's some wording issues where probably a plaintiff's lawyer could kind of squeeze through things, but I think it's way better than nothing. And I think in the absence of real insurance out there that's protective for everybody, this is a really good provision.
Yeah.
Yeah, let's use that as a transition point, maybe to keep kind of going into the other changes in this bill, regarding the existing natural medicine laws. So there's a few different buckets. I'm going to talk about them. Yeah, there's no perfect way to talk about them in order because they don't really go sequentially, but this is a good one to mention. One of the things that it adds is civil malpractice liability, for facilitators. Licensed facilitators in the regulated program, and I think Josh mentioned this, for physicians and healthcare providers if they're participating in the Ibogaine pilot program. For both those categories of people, they are shielded from civil liability, so from having to pay money damages for psychological or physical injuries that come from the natural medicine services or the Ibogaine services in the pilot program, unless the injury resulted from their intentional misconduct, gross negligence, or deviation from generally accepted standards of care. As you guys know, accepted standards of care in any sort of medicine or psychedelic work is hard to determine, right? So this is some of what Dave is referring to in terms of a plaintiff's lawyer being able to get around this. But that's what the law is. We'll sort of see how it plays out. These standards of care are evolving for mental health professionals, for physicians, for other healthcare providers. But the idea of this is not to protect bad actors. There's carve-outs for bad actors, but it's to be sensible and recognize that, qualified practitioners can still have difficult trips. They can facilitate difficult trips, especially with Ibogaine. There are risks to these, and for many, many people, the risks are worth participating in. But the hope here is that if we have this kind of protection, again, not for bad actors, but for qualified practitioners acting appropriately will attract more qualified practitioners to help provide these services, both in the pilot program and in the regulated program. All right, so with that, I'm going to sort of rapid fire through some of these other changes. Try to stay awake. They're actually interesting. And we'll try to leave about 10 minutes at the end for some of your questions. Okay, so another change that happened to the natural medicine laws that I personally support is it fixed this problem of disguised sales. So as you guys probably know, it's in the definition of the term personal use, where you not only are allowed to have cultivate, possess, and take natural medicines in personal use amounts for your own personal use, but that definition is also where it allowed you to share, to gift, and not sell natural medicine to other people while receiving payment for your bona fide harm reduction and support services that you provided in connection with the sharing. So you're never allowed to sell the natural medicine under personal use, but you were allowed to receive compensation for your time in providing these bona fide harm reduction and support services in connection with the sharing. A lot of bad actors, not a lot, some bad actors have started to use this as a way to disguise sales of natural medicine, which if you go back and look at the Senate bill and the history of the bill, none of this was intended to be allowed. We were very clear from the beginning that personal use wasn't allowing sales. But so there would be a situation where someone would come to you, you'd say, oh, you know, this is psilocybin, this is what you do with it. That's my harm reduction and support services. Here, take an ounce of mushrooms and here's your fee, and walk off with that. And that is not what was intended here. I don't personally have a problem with that model if we went that way, but that's not where Colorado went. And so there were folks disguising sales of natural medicine under personal use, and it was starting to become an issue and a topic of conversation. So what this bill did is it cleaned that up by saying now that bona fide harm reduction and support services that you're paid for must happen at the same time that the participant consumes the natural medicine, not just at the time that the natural medicine is shared, but at the moment that the participant actually consumes the medicine and experiences its effect. Again, we're one of the only states we're the only state in the country to have a personal use provision at all. I'm a huge supporter of it. I think it does a lot of things that the regulated model can't do. And, you know, they were carefully constructed to something that was safe and acceptable, and it was not a sales model. So this language, this change in the bill, I think is a step in the right direction in terms of ending these disguised sales and clarifying that personal use is and always has been about true community support, keeping people safe, healthy, and cared for during their trip, during their experience. So that's what this cleanup part does. There's a little bit more details around it. There's now a list of specific prohibited activities listed, like retail stores, vendor tables, recurring fees for sales of medicine, online sales involving natural medicine. Those are more clearly spelled out. But again, in my mind, this is just a clarification of what the intention was from the beginning.
Yeah,
okay.
and if
Go
I
ahead,
could just chime in, two things
please.
on that. It's like a lot of, what it clarifies is like there's no real change in law. It's already been illegal to publicly display natural medicine, to display it, on the streets and sell it. Like all that's been illegal, just kind of like clarifying that. And also, though, I will say, I'm deeply supportive of figuring out a way for adults to have safe access to natural psychedelic medicines that they can use on their own. And I think this is a matter of equity. This is a matter of self-agency, of sovereignty. And, there's a lot of work that, we've been doing with the Microdosing Collective and other groups to try and figure out, like, hey, what does safe access to psychedelic medicines at home actually look like? And so very, very much supportive of that. And but this, piece was sort of like a cleanup to like bring things in line with like what was promised to the voters, when Prop 122 was passed.
Yep, totally. We closed a loophole is in this piece is all we did in my read of it. Okay, I'm going to move on rather quickly. There's been a chunk of changes that I think are really good actually in terms of reducing the overall regulatory burden. This is an extensive setup As you guys know, any of you that have participated in it, it takes a lot of work for the regulators to apply all of these rules, keep up with it. So there's been a general trend to reduce some of that regulatory burden, which will hopefully reduce the burden and costs on the licensees and the applicants, which we hope will lead to a downstream reduction in the financial burden on folks who want to participate in this program. So I'd say the next three or four changes are kind of all in that realm. The first thing is there used to be a 5 license limit, so that such that one person was only allowed to have an interest in at most 5 licenses, whatever the license type was. Um, so 5 healing centers, 3 healing centers, and 2 cultivation centers, a testing lab, whatever the licenses were, you were only allowed to have 5. That was removed because it was getting to be quite an endeavor for regulators to have to track this down for every license applicant. This isn't to try to allow, like a big psilocybin monopoly coming into Colorado. If you look in Oregon, I think no one owns more than a single license. Out there. So this is not something that we expect that people are going to be rushing in to gobble up 10 licenses, 12 licenses. And if it does become a problem, it's something that we can bring up again and try to address. This is just a step to try to reduce that regulatory burden and hopefully reduce the downstream effects on folks wanting to participate. The other thing is there were provisions added to allow the state licensing authority to temporarily waive or adjusting the testing requirements if there's no licensed testing facility available to test the regulated natural medicine. This is a really good thing in a state where I believe we have only one licensed testing lab. If something happens there, we don't want the entire regulated program to come to a screeching halt. So this is some flexibility allowed there. There's requirements about what kind of third-party unlicensed labs could be used and the minimum qualifications there. But we can go look at the bill and see the details there. Again, it's a piece of regulatory flexibility that I think we really need. Similarly, there was a change made so that the state licensing authority is no longer required to conduct routine or pre-operation inspections of as a condition of licensure. Again, unless there's a reason to do that, I don't think we need to have that as a pre-programmed requirement. Again, reducing the regulatory burden. This next piece is kind of cool. There's a temporary premises permit. There's a fee associated with it, but a healing center can now apply for this temporary premises permit, which allows that healing center to operate temporarily at a separate location. And that separate location doesn't even need to be in its own jurisdiction. So it can conduct some administration sessions temporarily at a separate at a separate location, which is really good for underserved communities, reaching people you wouldn't normally reach, special events, outreach to a new community that maybe has not had any interface with that healing center. I think it's very cool. I think it'll be nice for healing centers to be able to do this. There's no obligation on local jurisdictions to allow this. So you still need to run down the same sort of zoning diligence that all these healing centers have been doing for their main location, but it's a nice piece of added flexibility. We talked about the facilitator liability protections. That's in section 6, I believe, of the bill. Again, not intended to protect bad actors, but just intended to attract quality folks who understand that this is a novel area with some risks. And then the Natural Medicine Advisory Board was restructured. Josh alluded to this at the very beginning. I think under the prior law, 8 members needed to have general expertise, 7 needed specialized expertise, and now all 15 voting members have to have expertise that's relevant to the natural medicine they're currently regulating or that they're considering. And there's some more details around that about how vacancies are filled, what the qualifying experience areas are. But I think it's really good, especially as we start talking about something like Ibogaine. That advisory board really needs to know what we're talking about, what the risks are, what the benefits are, and how we can keep people safe. All right, Josh or Dave, what did I miss on these more cleanup pieces?
I mean, just something to sort of like double click on or underline, as you said, Verena, is there'll be rulemaking around the temporary premise or temporary events permit. There'll be rulemaking around this like limited sales license. We'll see like what if anything will happen due to like the removal of like the 5 business like limitation, like will that like then change potentially like other regulatory requirements? I mean, that's the hope, but we'll see. And so I think a lot of things just to note is that the final rules around this will take place over time. And as Barina mentioned at the beginning, I think this bill goes into effect in early August as well. So.
Okay, great. Thanks everyone for hanging in there. Lots of interesting developments. Let's go to the questions, guys. Maybe we can just keep this pretty open. Josh, Dave, and I will as well. Let's look at the list of questions and just sort of jump in with the most frequently asked ones or the most relevant ones. Probably don't have time to cover all of them.
We have one question. What is the over/under for the number of license categories that DOR will create by the end of 2027? Dave, what's your thought?
Well, as I understood it, I mean, they just eliminated any limit altogether, right? So, isn't it? Is there a limit at all?
Oh no, no, the number of new licenses, like sales
Oh,
license.
the number. I'm sorry, the number of
Yeah.
new for the sales
It,
license.
like
Oh,
it was more tongue in cheek, It's just someone's question
I,
was.
oh boy. I'll take a guess and say less than half of the healing centers will get these because I think there's a limited purpose for having them, which is having, as far as I understand it, having this new entity buy and sell. And so what are you getting for that? And that's something to think about. And is there another way to sort of set up your structure to not have that? So I'm going to guess less than half.
Okay.
But hey, I'm a horrible. I lose all my bets practically. So
All right, Britta.
Courtney, I'm going to say I hope we're done with new license categories. I'm going to be optimistic and say we've worked out all the kinks. We don't need any more licenses. We've got this nailed down. It took a little bit of time to figure out everything. And that's what I'm going to, I don't know if I'm going to bet money on that, but I'm going to hope. I hope that that's the case.
and I think Rochelle had a question about and this is what is worth thinking about, like about this new license. Um, it, she was wondering if the new license can be used to facilitate microdosing. Um, Breen and Josh, I defer to you, but my understanding is like this. There's those are two separate issues, right? I mean, whatever the microdosing rules are, or the time period you have to wait, like, or even a temporary permit thing, like that's you can do all that stuff without just under current microdosing limitations. In Oregon, we had a rule where after a session, no matter what the dose, you had to stick around for an hour, which made microdosing kind of, semi impractical unless you were going to have some group event or something. But we reduced it down to like now it's 30 minutes. So I don't really, but to me, that having this separate license doesn't really address that underlying issue.
Yeah, no, no, that's correct. So in order for there to be take-home psilocybin from the regulated model, we have to change the law still. So there's still no like at-home microdosing uses in the regulated system without further legislative changes, which then will probably lead to like another licensing, which is actually not that bad.
That would be great. I mean, if
Yeah.
you could sell microdoses on a retail basis where somebody walks in and walks out, like that would be amazing. But that's not what this license does. This license just allows you to sell in the first place. Because the DOR has arguably strangely said you could never have sold it. Period. You have to bundle it with the services. So they're fixing a fix. I think they're trying to fix a fix, which some of us didn't even know was a problem in the first place. But it doesn't solve the retail walk out the store problem.
Yeah, and whoever drafted the Natural Medicine Health Act should have like fixed that, at the beginning. But we'll put that aside. The I really like, we have a question here. If psilocybin's approved by the FDA next year, which is possible under the executive order and the expedited review through the National Priority Voucher System, which both USONA got and Compass 360 for synthetic psilocybin and synthetic psilocybin analog. What happens with the state programs? And I find this question to be really, really fascinating. Um, you know, my first take on it is, well, one, what we're talking about in the state programs is we're actually talking about whole mushrooms, with all of the different alkaloids that come into it. And so I think there's still a a philosophical, scientific, and spiritual debate about the difference between whole mushrooms and synthetic psilocybin. And so like I think that debate will continue, and but I think there's another question though of, states historically regulate the medical practices. And so, will different states impose different requirements on what synthetic psilocybin or synthetic psilocybin analogs that are approved as federal pharmaceutical drugs, how they're administered in the state? And I don't know the answer to that question, but that's sort of like one thing to think about. And then the second thing to think about along those same lines is, these substances being approved will likely have some what they call REMS, like there'll be some like restrictions on their use as federal pharmaceuticals, and we don't know what that looks like. We don't know if those REMS are going to limit it to just like for a psychiatrist who has to be there and during the whole process, or if they'll be able to triage it, or if they'll be gatekeepers. It's like it's very unclear exactly what the approval looks like. But I think there's a big question, for this community, for the regulators in this community, for the policymakers in this community, is like, do they want to require a facilitator license for those who are facilitating FDA-approved psilocybin? Which is, I think definitely like a possibility and not necessarily like outside of the realm of what could be good policy. But I don't know, Verena, what your thoughts are on that.
Oh, super interesting. I feel like you covered it. I feel like federal rescheduling is going to be a whole separate creature, and there's going to be a lot to think about. I think the REMS question is really interesting. I think trying to think about psilocybin versus psilocybin, patented psilocybin products is also really interesting. And I think there's going to be a lot to unpack there. I guess I try to think of that in a whole separate silo in my brain than the Colorado regulated program so that I don't leak between the two. I actually wanted to switch gears for 1 second and flag two different things. Ed from Bipana has a comment that I guess I won't get into here just in the interest of time, but talk to your accounting firms about this dual entity structure. I just want to underline, I think everyone got it, but we said it, there's a lot of detail there. You don't need a sales license if you're a healing center invoicing people for services and medicine together. So healing centers don't panic. And if you're just operating as a single entity that's invoicing someone for the natural medicine services and the medicine, you're not separating out separate line items or receiving separate payments. You should not need a sales license. So that's important to say. And if you think you do need a sales license, talk to your accountants. Like they will help you unpack what you're trying to do and if it's even going to be if it's going to work from a 280E perspective or not.
And, sorry, even if you're in a room rental model, there is still a way, there are alternative ways to sort of bundle things together. And Ed's right. If you're going to have two separate lines of businesses, this was always my concern from a single entity situation to say we have two separate lines of business. Every cannabis business lost that argument except for one. And so it's a tough argument to make because you have to have standalone business. Complicated issue. Talk to your CPA or an attorney. But that's Ed brings up a good valid point there.
And then just to finish off on an unrelated topic, let's go back to the pilot program. Josh, maybe you can answer this. Carly was asking, and I think there's other questions that relate to this. How do we get this pilot program funded? Who's organizing that? What kind of funds are appropriate to collect for that? How do we hit this 150K threshold?
Great question. There's, Colorado for Ibogaine, I know is, working on this issue. ENC, who's the natural medicine advisor and cannabis advisor to the governor, is also working on this issue. People can reach out to us directly, if they're interested or if they have leads on who is interested. So, great question. Mm-hmm.
All right, guys, I think that's it. Josh and Dave, thank you guys so much. Audience, thank you guys for being here with us and for your thoughtful questions. Ping us with more specific questions, and I'm sure we'll be talking to some of you soon. Take care.